Good morning, everyone, to here in California and to the East Coast folks that are getting on their afternoon after lunch out there, joining us today for our compliance webinar. I'm Ryan Thurman with Contact Center Compliance, and with me I have David Kaminsky from Carlson and Messer, who is our featured presenter today regarding TCPA, Telephone Consumer Protection Act, changes, updates, cases, and just in general chaos. It's probably the best word. Thank you, David, for joining us.
My pleasure.
David and I met a few years back at a conference literally down the street from my office here in Santa Rosa, California, at a California Association of Collections event, when there was still a lot of stuff going on with TCPA. I think David at that time was just getting done with the cash call Leckler case and had been providing an update to everybody in the audience that was at the show about what was going on in the industry. And since then, he and I have really come together to try to provide that level of information to a little broader audience in the form of what we're doing today, which is a webcast or a webinar, to go through all the amendments that have happened and been proposed and are going to take effect, to the recent case law type decisions that have made TCPA a kind of a bonfire act of activity in terms of class actions, in terms of confusion about what type of dialing platforms people can actually use and what people can do with wireless contact or SMS messages. So we've got actually 2 hours now that we've penciled in for the day. We've extended things by an additional hour to allow for a little bit more content and, more importantly, questions, because my office, I know as well as David's, has been getting tons of questions about what's going on in the industry and what they can do to protect themselves, because it seems like every time you pick up the phone to make some telemarketing calls, to make some collections outbound activity, the complaint register is going up, and a lot of the class actions are looking for people to join up and go after bigger companies along with the CFPB out there. So it's a pleasure to kind of be able to bring this information to people in a format that they can get it in easy to access rather than going to the actual show. So what we are going to do is have this recorded today so that people can go back and look at their notes. We may also be able to provide the slides to folks so that they can not take copious notes, because there is a lot of information. So as far as the GoToWebinar format, if you haven't used it before, there's a nice little chat function or question format where you can text in questions as we go along, and we'll kind of compile them, maybe answer a few as we go in. But at the end, when we've got the additional hour, that's when we can do a little more Q&A. So feel free to do that so that we can try to get you as many questions as we can. David, like I said, has a lot of material on tap, so I'm going to kind of hand it over to him, and then towards the end I'll kind of give people a little bit more information about our company and how we play a role with wireless scrubbing and what some of your options, and we've got a special offer for attendees to help them get started with making sure that they are compliant with some of these rules. So David, I'm going to kick it over to you, and appreciate again joining us. David's one of the foremost experts on TCPA that I know, so I couldn't think of a better person to help break this information down.
Thank you very much, Ryan, and you could advance to the next screen. Thank you so much, everybody who's on the phone today. We do have a lot of information to cover, and so we're going to dig in right away. If any of you cannot hear me clearly, please let us know by writing in the chat box, and I will speak to you in a slightly different manner so that you can hear me clearer if it's not coming out clear. For those of you who need my information, you'll see it's in this PowerPoint. It's actually the slide just before the agenda. It's got my bio, but at the end of the bio is my contact information. If any of you should need that, it's all there with my direct dial as well. Very briefly, the agenda. We're going to cover the TCPA and its gamut, so to speak. We're going to talk about the law, the FCC's role, the regulations, and the FCC's 2008 order, which is still, even here it is almost 5 years later, we are still having issues with it, and it's still being ripped apart by courts and construed in various different ways. Consent is the big issue of the day, as you know. We're going to go over consent again. Of course, dialers is a huge issue. We're going to talk about dialers and where are we going with that and what's happening with that. What's the pressure that's being put on the FCC right now with respect to dialers? We're also going to get into compliance strategies and briefly talk about some of the FCC's October 16, 2013 rules that are going to be changing with respect to the telemarketing industry, which doesn't affect all other industries. Next. So just briefly, as you know, we're going to go over the law briefly. The TCPA enacted in 1991. Yes, everyone thought that this was going to be a law that was supposed to be handled in the small claims courts, and one case actually said that, and one case denied class certification because it says, hey, these cases were meant to be in the small claims courts, and although it's not exclusively relegated to those courts, we don't think it's suitable for class action. That case seems to be in the minority of jurisdictions. Next, of course, the intent was to curb telemarketing and avoid transferring costs, but as we see, that hasn't been happening. Very quickly, let's just go over the law. And as most of you know, we've got the law. It's 47 U.S.C. Section 227B. That's the law that we're going to be focusing on today. We call this the auto dialer ban law. This basically restricts calls made to a cell phone via an automatic telephone dialing system without prior express consent. I'll repeat that again. This law summarizes as follows. Basically what it does is it restricts calls that are made to a cell phone or other wireless devices, and then you're going to see, of course, other devices for which the called party is charged for the call, that are made to a cell phone where you do not have prior express consent to make the call. Of course, it's also calls and pre-recorded messages that trigger this part of what I call the cell phone prong of the TCPA. Next. Also there is the residential line prong, which you know, that's the 227, one back please, 227B1B section, and that basically says that if you're making a call to a residential line, it's restricted, but it's only restricted with respect to pre-recorded messages. So that's the difference between calls to cell phones and calls to landlines. If you're making a call to a landline, the liability is only triggered when you make a call via a pre-recorded message. So making a call generally, for everyone other than telemarketers, because they have to worry about the DNC list, but if you're making a call to a landline, it's only pre-recorded messages. That's the trigger for potential liability. On a cell phone, you've got the pre-recorded messages. That's a trigger. And you've got the calls to the cell phones via, let's say, just automatic telephone dialing systems. Again, with landlines, it's only triggered liability once there is a call made via a pre-recorded message. So you could use technically your automatic dialers all day to make calls to landlines, no potential liability until you leave the pre-recorded message. Then you have to have prior express consent. Next. So do you need to have a charge for a cell phone call in order to have a claim under the cell phone prong of the TCPA? Basically, the law and the way the law is construed itself and the case law that's come out says no, that you don't have to have a charge for a call. Next. So this is the landline prong. We just discussed it, and this is what we call the 227B1B section. Again, you need prior express consent for leaving a pre-recorded message on a landline. We're going to talk about the exemptions in a minute. Call forwarding. There's some confusion with this. Call forwarding. Someone takes their landline phone, and then they forward that landline phone to their cell phone. That doesn't trigger potential TCPA liability. In other words, if you're making a call to a landline, let's say you're using your automatic telephone dialing system, and you're using that dialing system, and you make a call, and you're making it to the landline, and you're leaving a pre-recorded message, well, that doesn't trigger liability if someone forwards their landline number to a cell phone. They can't cheat, in other words, and they can't try to create a claim in that method. There's a difference between call forwarding and call porting. Call porting is where someone actually takes their landline number, goes to a cell phone company and says, I want to use this landline number as my cell number, and I want it transmuted to a cell phone number. Once a number is permanently ported from a landline to a wireless number, then there is potential TCPA liability. The TCPA gives and actually it's the FCC gives a pass. If you call someone on their cell phone within 15 days of it being ported, you will not have potential TCPA liability for leaving pre-recorded messages or for calling without consent. But you only have this 15-day window. After that, with respect to a ported number, the FCC and Congress expects that you are going to, quote, scrub your data on a daily basis to determine what new numbers you're getting, maybe cell phone numbers, and everyone who scrubs, and almost every cell phone scrub entity or caller ID entity has with it the ported number list, or they should.
David,
that's something you always want to ask your IT people. When we have our scrub, are we also scrubbing the ported number list, and do we have a license for the ported number list? Next.
And David, yeah, one other quick point on the porting issue, which is you do have, like you said, you do have to have a license to do that. Either can come through a reseller like us, like Contact Center Compliance. You can get the data yourself or source it through us, but you need to be able to provide some sort of scrub within that 15 days. And because the file from Newstar that maintains the database is updated daily, there is a constant flux of people porting to cell phone, which is the majority of people at about 5.5 million across the country. And there's also people that port back to landlines, and that file actually is getting closer to almost 600,000 people now that are actually gone back, physically taken their cell phone and made it a landline. So you do have to do a constant check to make sure your data is accurate.
He's absolutely right. Okay, TCPA damages, I think you all know it's $500 basically for a negligent violation, and that is per call. Damages for a willful or knowing violation, we're seeing 3 times an actual award, or $1,500. What we're seeing is this. With regard to willful and knowing violation, the way this comes into play is mostly when you're in a case and the evidence shows that someone has expressly revoked their consent, hopefully in writing so that it's tangible, or that it was documented in your account notes that they did it orally, and then there are numerous calls or calls made thereafter. Some courts are construing those calls made after receipt of a written or oral revocation notice to be calls that are made willfully, because at that point you know someone's saying, do not call me on my cell phone. The courts are expecting you to honor that, and they're looking at damages after that kind of notification at $1,500 a pop. Next. Good thing about TCPA, no recovery of attorney's fees provision. That's the good thing. Of course, in class action context, there is backdoor methods for which attorneys almost always are able to recover attorney's fees in the event that a class is settled on a class basis or a class is certified as a class on a class basis. FCC's role, as you know, the FCC has the right to make regulations. They also have the right to implement the TCPA, and they've done so. They've done so in orders all the way since 1991, and they have detailed, complex orders. So we're going to talk about those orders in a second. Next slide. Let's talk about exemptions, and these are exemptions to residential lines. Most of you know this. There are exemptions that help you with regard to pre-recorded message calls to residential lines. Basically, the courts are saying, and the FCC has issued regulations, as you can see there, that if you are making a call that does not contain a unsolicited advertisement, meaning this is a non-telemarketing, non-sell, non-upselling phone call, it's just a pure, let's say, informational or business matter or commercial matter, meaning you're trying to collect a debt for you on the collection side, then the courts are interpreting that FCC regulation, what we call the commercial call exemption, to exempt calls that are made to a landline leaving a pre-recorded message even when there is no prior express consent. FCC has said this exemption is very broad and that all debt collection calls basically fit within it. Next, when we start looking at pre-recorded message calls to landlines, for which then, let's say you're making a wrong number call and you don't know that you're calling the wrong party, several cases, including Meadows and the Hoover case that you see there, say that this exemption is so broad, this commercial call exemption, that we believe that it exempts calls. And even though, yes, there was some kind of balance that says so long as it does not unreasonably affect the privacy rights of others, the FCC has really not commented on that. And the Hoover case basically says that this exemption is so broad that even when you're calling a wrong number, and the FCC has not yet determined in what situation a non-debtor's privacy rights may have been violated. So they said until they comment, sorry, the exemption is so broad, you make a call to a wrong number landline, you leave a pre-recorded message on it, and even if it's a wrong number, and maybe perhaps if you were told that it was a wrong number, you still may, and that's may, have a pass with the commercial call exemption. With regard to the established business relationship exemption, we're going to talk about how that, at least for the telemarketing side and possibly collection agencies, is going by the wayside as of October 16, 2013. The established business relationship will be gone, but the interpretation of that exemption and the definition of that exemption is so convoluted within the FCC regulations itself, when courts get to interpreting that, they can't even figure out what it means. So they usually resort to the commercial call exemption for pre-recorded message calls to landlines. It's cleaner, it's easier to understand, and the case law is very broad at interpreting it. Next. Okay, so we just talked about the, go back one, established business relationship exemption. As we said, it is going by the wayside, and that will be going by the wayside roughly in October 16, 2013. The established business relationship exemption is only a telemarketing exemption. There was not one for the debt collection industry. So the FCC, when it issued its recent order saying, giving all these changes to the telemarketing rules that only apply to telemarketers, they didn't say whether the established business relationship, once it's gone, will somehow remain for the collection industry. Since the collection industry was technically borrowing it, once it's gone on October 16th, it probably is gone forever. Okay, next. So let's talk about a recent case that came down that's very dangerous. This was basically a residential line call where someone was using the voice over internet protocol, a VoIP phone, and plaintiff somehow said, I was charged for the calls to my VoIP phone. Because this was a call to a landline, the way I would have, of course, argued it ad nauseum is that this is a call that falls into the 227B1A prong of the TCPA, which we call the cell phone or wireless line prong, because basically it's the B1B section, because that's the wired line prong. The B1B is the landline section of the TCPA. This call emanated to a landline, but someone was using this voice over internet protocol and said, I was charged for the calls and the pre-recorded messages. The court should have analyzed it under B1B, the landline prong. They did not. They analyzed it under the B1A prong. It's a terrible case. I haven't seen any court yet follow it yet. It's going to remain to see how other courts will interpret it. But court says no. Basically, under 227B1A, the cell phone prong, there's a section that says, or any other device for which the called party is charged for the call. So the court put this in the 227B1A cell phone bucket, not the landline bucket, even though it was a landline call, and then imposed liability upon the defendant and didn't use all those wonderful exemptions that we typically have for the pre-recorded message calls to landlines under B1B. Very dangerous case. Hopefully other courts will see that the logic of that court did not make sense, because you have a case, a call emanating to the landline, and that's how the argument should be made. This is a landline call, not a cell phone. Next. Let's talk about the FCC 2008 ruling. It's still plaguing us. We know that the 2008 ruling from the FCC gave the collection industry what we call a consent gift, and that gift is this. They defined prior express consent to creditors and collectors as this. So if you have a number that was voluntarily provided to a creditor in connection with some kind of debt, then the courts are saying that you, creditor, who got that number voluntarily, a cell phone number from the consumer, you have prior express to call that number with your automated dialing equipment merely by virtue of the fact that you were voluntarily given that number. Was it voluntarily provided orally? The FCC suggested one of the examples is providing it on a credit card application or some kind of retail credit transaction or some kind of retail application or other type of context where someone got the number voluntarily. So as long as the cell phone was given voluntarily, that number is deemed to be a number given with the consent of the consumer, and the creditor therefore has the right to call that number because they have consent to call it via automated telephone dialing systems and to leave pre-recorded messages. Debt collectors who step into the shoes of the creditor when they're collecting on their behalf also get the same consent by virtue of the fact they are calling up on behalf of a creditor who got that consent. So the consent has to be provided to the creditor in order to have this, what we call the FCC pass-through consent, to apply, in order for the debt collector to rely upon it. Sure, the debt collector can get consent directly. No problem with that. You get it directly. That's even cleaner. But if you're going to rely on this pass-through consent where your creditor got it, it just needs to be determined that the creditor did get the number voluntarily, and of course the best evidence on that is some kind of loan application, credit card application, somewhere where the person is putting their number down voluntarily. Next. So can it be verbal in writing? And I know there's a fight about this right now. But basically consent can be given verbally. It can be in writing. Nothing technically says it has to be in writing. In fact, the TCPA specifically said in the drafting of it that we're going to leave it open whether we're going to require this express consent to be given orally or in writing. So that's really an open-ended question right now, and basically most courts are interpreting that consent can be given in writing. It can be verbally. If it's given verbally, make sure that you have a system in place to document that, because if you don't have a system in place to document that, how are you going to ever prove that, yes, we got verbal consent on this day by this person? If you have a recording because you record all your calls, well, that's even greater evidence, of course, that you have consent. Of course, having the consent in writing is a terrific help as well, especially with respect to proof anytime you may be called to task on the issue. Can consent be provided via a website? Yes. If someone puts their number down via a website application, and they do that, the Roberts versus PayPal decision, very new, just came out literally about a week ago. That case says that you can get consent via a website as long as someone, that's, let's say, an electronic e-sign signature or something of that, where someone's filling out some kind of application online and they either e-sign or they fill out everything out and then they transmit it. You have documentary evidence someone has given your number voluntarily. Can it be provided by a third person? No. The consent basically almost always has to come from the consumer themselves. Let's talk about timing of it. When do you have to get that consent? And there's a little bit of fight about this right now. So the FCC in its infamous 2008 ruling in this paragraph 10 basically says that consent is deemed provided only if given to the debtor, to the creditor, during the transaction that resulted in the debt owed. Okay, that's what they do say in paragraph 10, but throughout the FCC's own ruling, this 2008 ruling, 3 times they say consent is proper so long as you give us the wireless number, the cell phone number, in connection with an existing debt. You give it in connection with an existing debt, you're good to go, creditor, and you're good to go, debt collector who's collecting on behalf. a Ninth Circuit decision, Meyer, you'll see at the bottom of the page, they looked at this issue. When they first said in their first iteration of their ruling on this issue, the Ninth Circuit first said, oh no, according to paragraph 10, it can only be given during the transaction that gave rise to the debt, and if it was given at any time after that, sorry, no consent. The actually Ninth Circuit looked at that issue again, rethought it, and said, you know what, as long as you give it in connection with the debt, sometime before you're making the call to the person on their cell phone, you get that number voluntarily, you're good to go. So that's a really great pronouncement by the Ninth Circuit on this issue. I think it's the only Federal Circuit Court of Appeals that has actually interpreted this issue. So it does carry some weight, not throughout the country, but at least with regard to all the states bound by Ninth Circuit law. Next. Let's talk about what is consent. So again, it's the providing of a cell phone number and that you can get voluntarily, you can get from a credit application, et cetera, et cetera. That's very important, okay? Next, just remember, skip tracing, that's very problematic. I think most of you know that. If you skip trace numbers, you don't know what the origin is of those numbers. Yes, there is an instance where you will skip trace numbers, and you may have numbers that you find in your skip trace that happen to be numbers that you already have on accounts for which you have consent to call those numbers. But it's a risk. You never know. Most of you are not skip tracing until, or an account, let's say, would not be within a skip trace campaign unless there are not good numbers on the account. But if you get a skip trace number, you load that into your dialer, there's a good chance you don't have consent to call it, and it's a risk. Never load, and we'll talk about this later, but never load skip trace numbers into your dialers and start calling them because it's just a trigger for potential TCPA liability. And in this Meyer case, that skip trace issue gave rise to a class. And even though the defendant said, hey, a lot of these skip trace numbers we got were numbers that we already had consent for, the court said, okay, well, prove it to me. Why don't you show me a batch so I could see that there's, that you've got this individualized issue in your case. The defendant couldn't prove it in that case, and it's very difficult. So the court was then went ahead and certified a class, a skip trace class. Next. So can consent be provided by a third party? We talked, not a good idea. It's very rare in which a third party, even a spouse, has consent. And you don't even want to bother with that, because if you get it from a spouse, then you're going to get into this whole factual dispute potentially of whether the spouse really had authority to give the consumer or a debtor's cell phone number to you. Terms of consent could be limited. Let's just say that you've specifically limited the consent, or someone gave you the number, said you can only call me this number if there's an emergency or if I have a payment problem, etc. Generally, courts may honor certain terms of consent, but they're going to look at them realistically, as they did in this Weiss case. They said, hey, we're only going to give you 3 text messages a week to update you regarding the Pittsburgh Penguins sports agenda. Well, they actually gave more than 3 text messages a week, so the plaintiff sued because he got more than 3. Court said, look, basically you wanted text messages regarding what's going on with the sports team. We gave you them, so what? You got a couple more than they said. It was basically within the purview of the type of consent that you gave. So courts will look at this issue realistically, but just be careful if someone has actually limited consent. We already know that pursuant to the FCC's ruling on the soundbite petition, a confirmatory text message, which many companies do, after someone types the word stop, to stop a company from texting them any further, many companies would send a confirmatory text message back saying, this is just to confirm that you just texted us to tell us not to give you any further messages. FCC has ruled that that confirmatory text message by a company doesn't violate the TCPA. Next. Okay, let's talk about the Mays decision, which I know is all on your minds. It's that Florida decision that recently came out and sort of turned the FCC's consent ruling on its head. And the part of the ruling I'm talking about is where the FCC said, hey, creditors, if you get a number voluntarily, either orally or on an application, for example, we're going to deem that that number was given to you with consent. You have the right to call it via your automated telephone dialing equipment. and you're good to go. Debt collectors, you stepping in the shoes of the creditor, you are good to go as well. You can call that number as if you had consent yourself, because the FCC said you step into the shoes of the creditor who already got consent either via an application or orally, and it's documented. Mays said this: I am not prevented by this Hobbs Act, and I don't want to get into too much detail in that, but I'll explain that in a minute. I'm not prevented by the Hobbs Act from looking at this FCC ruling. So I'm going to look at the FCC ruling and see if it violates the TCPA. The court said, gosh, the TCPA itself, in the language that it's used in the statute itself, says you got to get express consent. Well, putting a number on an application and deeming that you have the right to call it via automated telephone dialing equipment is not express consent, that's implied consent. So the FCC is giving you something that's contrary to a clear and unambiguous statute. And I believe as a court that it's contrary to the statute, so I have the right under the Supreme Court law to ignore this FCC regulation because it's contrary and contradicts Congress's clear statement. Once the statute on its face and the language therein is clear and ambiguous, courts are generally required to stop. Courts are supposed to interpret the statute as it is on its face and not do anything further. So this court says, I can look at the FCC ruling. I can determine if it's reasonable. I don't think it is here, so I'm going to ignore the part where the FCC says a creditor who gets a number voluntarily on an application or otherwise has prior express consent to make a call. So that's a very problematic decision, because what this court essentially did, at least if you think about it from the creditors alone, or credit grantors, that means that every creditor throughout the country technically who has consent, let's say because they got it via an application, all of a sudden now doesn't have that consent to call someone on their cell phone using their automated dialing equipment, because this court is saying, well, that's not express consent, that's implied consent, and I think, the court says, I think it's contrary to the statute. Very dangerous ruling. Then this court went even further. It said, okay, first of all, even if I'm not right, and the FCC ruling, let's say I don't have the right to compromise it, and let's say it does come into play, I think it only applies in the creditor-debtor context, meaning a retail creditor and debtor collecting on behalf of a retail creditor, because that's the way I sort of read that paragraph 10 of the FCC ruling, and that's how I read all the cases interpreting where this really comes into play. There's nothing that says that. Yes, paragraph 10 of the FCC ruling does say, it does use the word creditor, it does use the word debt collector, but we don't think that the FCC literally meant to limit the implied consent gift that they gave in their 2008 ruling to only a retail credit transaction. But this is how this court saw it. Then this court went a step further and it said, okay, let's just say I'm wrong on the first thing, that I can't compromise the FCC. Let's say that I'm wrong, that the FCC ruling does apply, and that it does actually apply to a medical debtor, medical provider. I said, I'm going to go a step further and say that, well, wait a second, this, the consent at issue here was provided to the hospital generally. It wasn't provided to the actual creditor, who was someone who was an entity who provided services within the hospital chain while plaintiff was in the hospital. So the creditor, so the court is saying, well, wait a second, even if this FCC ruling does apply to medical debt, I'm sorry, it doesn't apply to the actual creditor at issue because they never got consent in the first place. It was provided to the hospital. So they're saying the debt collector collecting on behalf of that particular creditor who never got consent, the FCC ruling here isn't going to help you. The defense in that case, of course, argued, wait a second, giving the consent to the hospital should literally go all the way down the chain, and any entity, who then, quote, provided services to the plaintiff should be able to get the benefit of that consent that was provided to the hospital in the initial intake form. This court disagreed with that. Just yesterday, this court has granted something called an interlocutory appeal, and what they're saying is this: my decision is convoluted and it has far-reaching effects and does affect the outcome of this case, so I'm going to allow this matter I'm going to certify this part of the case and these 4 issues to immediately go up to the 11th Circuit Court of Appeal. And so now now the defendant is going to, quote, request that the 11th Circuit Court of Appeal actually take this case, look at the issues decided by the Federal District Court, which is the lower level rung of the Federal District Court, of the Federal Court layer, and they're saying, okay, Federal Court, 11th Circuit Court, please look at all these issues that this District Court decided, and let's decide if they were right. I have a feeling that the 11th Circuit Court of Appeals, because these are very complex issues, and issues regarding whether a district court has the right or jurisdiction to even interpret a final order of the FCC. The 2008 ruling is a final order of the FCC. The question is, does a district court have the right to challenge those rulings? That's going to be one of the issues that's going to be tested, and that's what this court has actually raised. So right now, just to give you a feel for this Mays case is only a district court decision. It is not binding precedent because it is not from a Federal Circuit Court of Appeals. In other words, a judge sitting in the courtroom next to this Judge Scola who issued this particular Mays ruling, he could disagree with his brethren right next door in the same courthouse and come out with a different opinion if he wanted to. Yes, the way the court decided this case could be persuasive to courts within Florida, federal courts within. It could be persuasive to a federal court sitting in Nevada or California if they chose to say, hey, I like the way this judge analyzed this issue, and I agree with him, and I'm going to follow this sort of the Mays analysis, but he may not. I know this is causing consternation, but the good thing is I think this matter will go up to the 11th Circuit Court of Appeals, and then it will be decided what is the law here and how far does the FCC ruling go. Can district courts challenge final FCC rulings? And I know it leaves a lot of things that are unsettled. I know it really is causing tremendous issues for all of you in the medical, who collect medical debt, because you're saying, wait a second. The plaintiff who enters a hospital always gives their consent initially in an intake form or some kind of consent form to the hospital. They're not giving it to every single, quote, vendor or provider of services that may come along the chain in a hospital, such as a radiologist, such as an anesthesiologist, et cetera. To say that only the creditor gets this consent and it's only the hospital and then no one else down the chain is, how do we ever get consent in this regard? This is an issue that, forget about this judge's ruling, has really plagued the medical debt industry for some time. Next screen. And this has been a question out there. The FCC could also say that, wait a second, we expanded the express consent, expanded it from that which is already in the statute, which says express consent. And we're really saying that by putting it on an application, we're going to deem that you have consent. And most courts are saying, look, let's just be honest, that's really implied consent here. The question is, does the FCC have the right to grant that gift that it gave to the credit and debt collection industry or to other industries who get information and telephone numbers voluntarily? That's the question of the day, and the FCC could say, I'm not saying they will, but they could say, wait a second, this was a gift, and we know we were sort of expanding the TCPA, so we were doing it in a very narrow fashion, giving it only to a creditor and then a debt collector. Will they limit that to a retail debt collector or a retail creditor? Remains to be seen. Many of you may know the Mitchum case. This is a case from Illinois, and this case said, wait a second, when an orthopedic company does get a number, they get it voluntarily, then the collector collecting on their behalf does have the right to call that number as if they had consent, because the court basically said, look, you gave the number voluntarily, and basically you gave your number without restrictions. Therefore, as a creditor, the medical debtor here, the medical creditor here, Midwest Orthopedics, had the right to call you, and so did its debt collector collecting on your behalf. So this is a good decision. Yes, it's contrary in some part to the Mays decision, because Mays doesn't think the FCC ruling does extend to medical debt, and this ruling did. So it's a very good decision. So as I said, the decisions are all over the board, but this decision certainly helps the medical industry. And so if you're dealing with one of these issues with regard to FCC consent in the medical debt collection context, use the Mitchum case. Next. Let's talk about another mono decision just very briefly. It's very similar to the Mays decision, but this court basically said, hey, look, defendant, you're claiming that you have consent basically on a class-wide basis to call everybody on their cell phones or any number that they provide to you on their hospital consent form, because that's the only way you get numbers. Well, that's fine. This court said, I'm sorry, but I think I can then certify a case because it's everybody who you called on the cell phone that may be listed in these consent forms. Just because a court, I'm going to make this simple, certifies a class action doesn't mean the defendant loses. The defendant has still the right to challenge what is called the merits of a case. It still has the right to raise the fact that there was no consent. It still has the right to challenge the fact that there may not have been consent to the lead plaintiff or to everybody there. But this court wasn't looking at that issue on the merits of just saying, hey, you got a group of people who you called possibly without consent. I'm going to certify the case. You work it out in the wash later on. And so that's what happened in this mono case. Next. Let's talk about what's not express consent. We've got to be clear here because consent is starting to be narrowed and limited by various courts who are interpreting it. So I think that it should be applied in a narrow fashion as well. Don't ever capture numbers via caller ID and then load them into your dialers. You never know if you have consent for them. If someone gives you an oral request to stop calling them on their cell phone number, I would honor it. Yes, there are decisions we're going to talk about revocation of consent, which are contrary. I'm telling you the safest way. Someone gives you verbal consent to stop calling me on my cell phone, have a custom and practice to document that in your accounts there, and therefore prevent those numbers from ever getting loaded into your dialers. It's just the safest practice to take. Skip tracing, we already talked about. It's dangerous. Next. Don't skip trace and load those numbers into your dialer. We already talked about this issue. Is express consent that's in the FCC ruling, is that express consent gift that the FCC gave to creditors and debt collectors, is it limited to just the creditor debt collector circumstance? Well, this court in Thrasher said it was. The matter went up to the 7th Circuit Court of Appeal. The 7th Circuit Court of Appeal said, hey, I'm throwing my hands up here. We're going to reach out to the FCC and say, FCC, what did you mean by this whole FCC ruling? Did you mean to limit it solely to the creditor debt collector context? And unfortunately, the FCC never had a chance to resolve that issue. They were going to give a brief, I believe, on June 25th, but the case resolved, and it's no longer on appeal. So this issue is not going to be resolved by Thrasher, but it looks like it's going to be challenged and probably go up to the 11th Circuit Court of Appeal in the Mays decision. Both of these courts had different decisions, similar decisions, because the Mays court also said, hey, I think this FCC ruling does not apply to medical debt. It only applies in the retail credit transaction context. That's going to be challenged, obviously. Next. And then again, the 11th Circuit, if they're faced with that issue, they may say, hey, we don't know what the FCC meant. They may reach out to the FCC, just like Thrasher did, and ask the FCC to comment and say, what do you say about this issue? It's your provision. How are you interpreting it? I've actually spoken to the FCC directly in a face-to-face meeting in dealing with various TCPA issues, and I literally asked them about this issue. They were a little cagey, but they said, we mean sometimes what we say, and we say what we mean with a little bit of explanation on the side. Sometimes we do say things that appear to be narrow that we mean in a broad context. Sometimes we do say things in a narrow context, and we mean just that. So they wouldn't give me really a roadmap as to where they were going with this, and I don't know how they're going to explain it. Let's just look realistically. They could interpret it in a narrow context, saying this was a stretch of the TCPA to begin with, so we're going to construe it narrowly. Hopefully, that's not how it's going to be interpreted. Okay, what about the burden to prove consent? Who has that burden? several courts in California, including the Ninth Circuit Court of Appeals, does indicate that you do have the burden. If the FCC 2008 ruling controls with regard to consent, remember what they said therein in some of their paragraphs. They said, creditors, it is your burden to prove consent. You have that burden, and you're in the best position to prove it by virtue of loan applications, credit applications, sales slips, et cetera, where someone has written down their number. You've got the evidence. And debt collectors or those collecting on behalf of a creditor, you have that obligation and burden as well to prove consent. So this is and several courts are looking at the FCC ruling, and for those courts throughout the country that look at the FCC ruling and apply it as it's written, they're going to say, you defense have the burden to prove consent. So that's an issue that becomes problematic. It becomes more problematic when you're dealing with a class action, especially if a court goes so far as to say, you defendant have to prove, you have the burden of proving consent on a class-wide basis, that you have consent for everybody that you called over the last 4 years, if that's the statute of limitations period. Well, that's a daunting task. How are you ever going to prove that kind of consent on a class-wide basis? There are some entities that we've seen recently, such as Honda in a recent case called Jameson, where Honda said, hey, every number that we get is with consent because we get it only by virtue of a creditor loan application. So we're not getting consent to call a cell phone, or we're not calling a cell phone by any other manner other than someone voluntarily putting out an application. The court liked that and said, okay, basically you've proven that you have consent. I'm not going to certify a class here because you have basically a basis to prove that on a class-wide basis you have consent. Not every creditor can prove that, and then once you get to a debt collector, how does the debt collector to prove consent on a class-wide basis unless they have a creditor that has an easy mechanism and manner in which they obtain consent? So this is a difficult issue. Placing the consent on the defense is very difficult. Next. Revocation. This is what's tricky right now. Some courts are saying this. Oral revocation is fine. Written revocation is fine. Other courts are saying, well, wait a second. If you're in the FDCPA context, and depending on how you revoke your consent, let's say you say, don't ever contact me. Well, some courts are saying that's an FDCPA cease and desist. So if you're in a debt collection context, you got to make that request in writing. Other courts are saying, sorry, the TCPA and the FDCPA are two independent statutes. Someone says, don't call me on my cell phone. That's not a cease and desist request. That's only governed by the FDCPA. That's an oral request to stop calling me on the cell phone, and there's nothing that says you can't do an oral revocation. The FCC doesn't say you can't orally revoke, and it's 2008 order. In fact, they say you can, and most courts are saying, and most cases are saying, you can get consent orally, so why can't you revoke it orally? Next. We talked briefly for a second earlier about this Geiger case, and Geiger says, look, I think the timing of revocation is another issue. They're looking at the 2008 ruling from the FCC and construing it very narrowly, and this is what they're saying in Geiger. Geiger says, hey, if you put your number down in a credit application, consumer, well, sorry, that's it. Unless you give instructions to the contrary at the moment you're giving your number on a credit application. Let's say you put your number down on the line that says, what is your cell number, or what's your phone number, and at that point you don't, and you don't put down instructions that say, but don't ever call me on my cell phone unless you have permission to do so, or something like that, then this court is saying, then, sorry, if you put your number on application, the creditor has the right to call you, and you cannot revoke your consent. Once you put it down, you can't revoke it. And a couple cases have followed that. The Sonder cases have followed that logic. So has in a sense, the Cardoso case has, and in a sense, so has this Kenny case at the bottom of the screen. I like these decisions. They're great because they help the defense, but in some respects, they're not realistic. Does that mean if someone gives you their cell phone number, they can never revoke it, even if your number changes? That doesn't make sense. Does that mean that if you no longer have the same phone number and you want to revoke it and you don't want to give a new number, that you have to give a new number and they have the right, a creditor has the right to call you on it? That doesn't make logical sense. The Giga case has gone up on appeal to the Third Circuit Court of Appeals. It was already heard back in late March, and a decision has not yet come down, but I believe it will very shortly. So it'll be interesting to see what the Court of Appeals says on this revocation issue. And so we'll keep you very closely posted, because it's going to be, that will be, whatever the decision is, it will be binding on those federal courts that are within the Third Circuit jurisdiction. Next. But basically for now, as I said before, and I'm going to go over it in the compliance section, if you get an oral request, the most prudent course of action is to honor that oral request, to stop calling, document it. Let's talk about dialers. You know, this is also the issue of the day. An automatic telephone dialing system, what is that? It's confusing, but it's right there in the TCPA. The TCPA defined it. And they defined it as some kind of equipment that has the capacity to store or produce numbers to be called using a random or sequential number generator. Let me just stop right there for 1 second. Most of the dialers that I believe all of you on this phone call today are using do not have dialers that contain random or sequential number generator programs. So technically, if you don't, the question is, do you have a dialer that falls into the purview of the dialer definition under the TCPA? That's the question of the day. Because it's, again, defined as equipment that has the capacity to store or produce numbers to be called using a random or sequential number generator. Let's look at the 2008 ruling. We're back to that FCC ruling again, because what the FCC did is reinterpret the dialer definition in the TCPA, and they expanded it. And courts have even noted that they've given expansive definition of that. So what they said is this. They said, okay, we're going to just deem that for the purposes of the TCPA and what is a dialer that falls under the purview, we're going to say it's predictive dialers. So all of you out here using predictive dialers, we as the FCC say that you're using a dialer that falls into the purview of the TCPA. We're going to go a step further. We're going to say it's any dialer which has the capacity to dial numbers without human intervention. Well, that is an extremely broad pronouncement. Equipment that has the capacity to dial numbers without human intervention, well, that's basically anything. The FCC doesn't even know what that means, and they've said that in a recent conference. How broad is that? What is that? What equipment? Is that your iPad today? Is that your computer? It's a very broad pronouncement. Yes, it needs to be challenged. Yes, it is overbroad and does sweep into potentially anything or any probably dialer out there, because most dialers, if programmed or when programmed, can basically dial without human intervention once you upload a list of numbers. I'm not saying every dialer. I'm not saying that you have a dialer that does that. But from what I've seen, most dialers in their native form can do that. So the courts are saying, next, courts are saying, well, gosh, the courts are looking at the FCC ruling, and some courts are relying on it. They're not relying strictly on the TCPA. There was a decision from the Ninth Circuit Court of Appeals called Satterfield. And Satterfield said, hey, the TCPA says what it says in its dialer definition. It's clear and unambiguous. Congress says what it says, so that's the end of the discussion. You don't look at the FCC's regulatory interpretation of a dialer because there was no need for it. And if you're not allowed to look at the FCC's definition, then maybe there's a good argument that many of you do not have a dialer that falls into the purview of the TCPA definition. The problem is, it's the courts that are looking at that FCC definition of a dialer. It's very problematic and dangerous. So the FCC has expanded it. But the reason the FCC says that we're making this dialer definition so broad, and we're even sweeping in predictive dialers, is because all of their reasons for the dialer ban on page 30, but none of those reasons today exist. And I'm not going to get into it. They just don't. So that's one of the arguments to say why your decision of why you went so far in reinterpreting what a dialer is under the TCPA doesn't make sense, because none of the articulated grounds for why you said you needed to broaden it apply today. Next. There's various petitions right now out that are challenging the FCC on this dialer definition. That's a good thing. Trust me that the entire banking industry, all of the creditor and the collection agency entities out there are fighting to change the dialer definition. There are various petitions that have been filed with the FCC asking the FCC for a declaratory ruling, just like they gave in 2008. Well, these entities are saying, give us a declaratory ruling that says that our dialer is what is the definition of the TCPA. Let's just go back to the TCPA definition. And if you don't do that, well, at least say that these predictive dialers that we're using allow us to use them. You are crippling businesses throughout the country. The banking industry, the airline industry, the entire healthcare industry is fighting the FCC right now. The ACA International is, NARC is, and I can go on and on and on. Contact Center Compliance, all of these entities are trying to fight to say, look, you're choking industries by saying we can't use our predictive dialers. No one is manually dialing today. No one can, because if you do this, FCC, you will ship all of our jobs overseas, you will cripple American businesses, and you will cause companies to fold. This is literally the talk that I had with the FCC Chief Bureau, who's responsible for TCPA implementation back in April of this year. I literally had this discussion with several others. And we told them, you're going to implode businesses, and you're going to destroy many American businesses if you keep this up. The FCC knows it's got a problem on its hands. The pressure on the FCC right now is relentless. It'll be interesting to see how they rule on this Communication Innovators petition, because they're saying either go back to the TCPA definition and forget your definition, FCC, on what a dialer is, or just do us a favor and allow us to use our predictive dialers. I asked that same relief as well from the FCC and its bureau chief and all of its TCPA gurus who were sitting in the room. I said, lift this ban, give us a limited right to use predictive dialers if that's what is the compromise here, but you've got to help us. You're crippling businesses. Next. It remains to be seen how they're going to rule on this Communication Innovators petition. It's going to be seen how long it takes. They're concerned with unintended consequences by going back either to the TCPA's pure definition of what a dialer is, or by allowing entities and all entities to use predictive dialers. It's going to be a very, very interesting road. Next, I just briefly talked about the Satterfield decision. Great decision from the Ninth Circuit, because it says, hey, forget about the FCC's dialer definition. Just look at the TCPA. The discussion ends there. Then you have the right to challenge whether your dialer falls into the purview of the TCPA. What's very strange is Ninth Circuit issued another decision 3 years later called Meyer. Meyer looked at Satterfield, didn't really get into what Satterfield said about its own pronouncement of what an automatic telephone dialing system is, and just basically looked at the FCC ruling and says, oh, defendant, you admitted that you use a predictive dialer. The FCC in its 2008 ruling says a predictive dialer falls into the purview of the TCPA. Therefore, you have a dialer, defendant, in this case, that falls within the purview of the TCPA. Defendant did make the argument, wait a second. That FCC ruling is contrary to the statute and therefore should be struck by you, the court. The court said, and whether they were right or wrong remains to be seen, but the court did say, sorry, defendant, you didn't raise that argument in the court below. You should have. So here on appeal, you can't raise that argument for the first time, which seemed to suggest that the Ninth Circuit Court of Appeals would have entertained that issue of whether the FCC's dialer pronouncements were really contrary to the TCPA and therefore were improper, because the TCPA has already spoken. And this is an issue that I believe can still be challenged. If we're looking at that Mays decision in that court, the question is whether if the court is saying in that Mays decision, I don't agree with this consent definition because it goes too far and it's contrary to the statute, then that same court, if it's using its own logic, would have to say, okay, the dialer pronouncements by the FCC, which really is redefining what Congress wrote in the TCPA, that went too far, and therefore those pronouncements should be ignored, which then gives at least a level playing field. This is what I am trying to work for all of the industries, and all of the creditor and consumer bars. I'm sorry, the the defense bars are working for is to try to make a level playing field. Just give us something we can work with. If we go back to the TCPA's definition of a dialer, then we have something to fight. Yes, there are multi-layered and level fights within the TCPA's own definition of a dialer, but it puts us more at a level playing field with the consumers so we have something to work with. Those FCC pronouncements in the FCC 2008 ruling are frankly, and forgive me, ridiculous, to where it's bringing everything into the fold. My Droid phone now falls into the fold of an automatic telephone dialing system. So trust me, the moment that I or someone else gets sued for dialing someone on your cell phone via some kind of automated means or from speed dialing on it, once I get sued, then all heck is going to break loose, and there's going to have to be immediate changes by the FCC. Because now you're going to sue your friends for calling you on your cell phone. This is how ridiculous can you get to, but that's how broad the FCC's 2008 dialer pronouncements are. Next. And we're going to start moving quickly here. I want to make time for plenty of questions. So preview mode, that's one of the questions of the day, and I know many of you are thinking, gosh, please get into the Nelson versus Santander case. Preview mode, again, just to explain what it is for most of you and the way most of you are considering preview mode, that's where an account will come up on a account representative or debt collector screen, and you'll see the number, and let's say it's a cell phone number, before you, quote, before that number is ever called via automated dialing equipment and automatically launched, the account person or the debt collector can make the decision to either click on something or press a keystroke, and that will give the instruction to the computer to launch the call, which usually then gets launched through a dialer. That preview mode was implemented by many companies as at least a means or a proposed workaround to get around the dialer pronouncement of the FCC when they said any equipment that has the capacity to dial numbers without human intervention. Companies were saying, oh, well, look, you know, now that we're dialing in preview mode, it requires the person to click. That's human intervention. Next, well, this case, of course, was looked at by Nelson versus Santander. And next, the key to that FCC ruling is, capacity. Because the FCC uses the word capacity, and the FCC actually questioned me on this issue. They said, well, in our dialer pronouncements in 2008, didn't we merely just take the word capacity from the statute itself? So we didn't do anything that's not already in the TCPA. We didn't go beyond it. I said, yes, you did. The TCPA talks about capacity using a random and sequential number generator. You talk about capacity to dial numbers without human intervention. Those two things are very different. And some courts said you went so far as to, quote, redefine what the dialer definition is under the TCPA. That caught the FCC's attention because they were sort of wide-eyed looking at me like I had just shot a deer or seen, I had the deer in the headlights look. It was quite interesting. And so they just stopped for a moment when we discussed this because the FCC now is saying, well, it's the capacity to dial numbers without human intervention that is so far and beyond what the TCPA's definition is. It's so broad, that's bringing everything into the fold. Next. So when we talk about this Nelson case, the Nelson-Santander case looked at this whole issue of preview dialing and basically said, gosh, we think this whole preview dialing that this company said it was using by clicking on something to dial a number, that's just a red herring for us because the FCC has given an expansive interpretation of a dialer. And they're saying it's equipment that has the capacity to dial numbers without human intervention. And even though you may have used it in preview mode at a particular moment, your equipment that you ultimately launch the call through has the capacity to dial numbers with automation without human intervention. So the court looked beyond what was literally being done and said, sorry, you're still using equipment that has the capacity to dial without human intervention. Gotcha. You are using a dialer. So this court was saying pure preview dialing, as it was conceived in this Nelson versus Santana case, is not a way around the the FCC's ruling on what is a dialer. What the court seemed to be suggesting but didn't say, and what I have argued for years is that I have predicted that courts could interpret the FCC ruling in this manner and preview dialing in this manner. If the company, if the dialer that you're using has been, quote, the programs have been disengaged so it cannot dial without human intervention. In other words, no dialing campaign that you put it through could be dialed in unless someone literally clicks, then you would have a very good argument that you have a dialer that no longer has the capacity to dial without human intervention because you engaged it. Sorry, because you disengaged it. Would a court go so far as to say, okay, you have equipment now that doesn't have the capacity to dial numbers without human intervention because you disengaged the programming that allowed it to do it in the first place. It's not even in there anymore. You've literally extricated that program or that chip or whatever. But I'm going to still argue as a court that, sorry, if you reconfigure this dialer of yours and you put back that program, it is a dialer that has the capacity to ultimately dial without human intervention. That's really taking things too far. I mean, I could see maybe a court could do that, but I believe that if the court says you have disengaged the capacity that allowed this dialer to dial without human intervention, it can no longer do so. So if you're dialing in this preview mode and clicking on something, and there's no way your dialer could have ever launched that without that capacity, then you may have a dialer that now is outside of the FCC's 2008 ruling. It's got to be done in a very, though, specialized manner. I can't give you, of course, the full, platform from A to Z of how you would do that and how you would make the argument because it's too complex for this, but that's just to give you a flavor of how you would get around it. This decision is dangerous because it finally said, okay, this preview dialing, which so many people have been using, this is the first pronouncement that says it's just a red herring and it doesn't get you around the 2008 FCC ruling. Again, this is only one court, one federal district court sitting in Wisconsin. Again, it's not even binding on the courtroom next to him. Could a court anywhere in the United States use this as persuasive or suggestive authority and say, gosh, I agree with the logic of it, I'm going to follow it? Sure, they could. Could they go in a completely different direction? Yes. This is not a pronouncement by a federal circuit court of appeals on this issue. Next. The logic of this court, though, does make sense, and other courts could potentially follow this logic. Okay, let's talk about, remember, there's other courts throughout the country that at the district court, federal district court level, the lower level of the federal district courts, you can't even challenge a final FCC ruling. Some courts will say, sorry, my hands are tied. I can't challenge an FCC ruling because of this Hobbs Act issue. So the FCC says what it means and means what it says, and that's it. I got to follow it. I don't have the right to disregard it. Next. Standing for wrong numbered calls, there's a couple of different theories out there. One theory is called the Soppet theory, and it says, look, to have standing to bring a TCPA action, you've got to be the subscriber. Some other courts have suggested that as long as you're a person is the regular user of the phone call, then you are any called party under the statute, and you have a right to bring a claim for a cell phone claim. Next. There's a court right now, a case that is actually challenging standing, because what they're saying is, gosh, if we're calling a number and that number has been reassigned to someone else, how can we ever figure out if the number has been reassigned? How can we ever gauge our potential liability under the TCPA? The TCPA simply says if we have a number that is given to us with express consent, we can dial that number via our automated telephone dialing equipment. Well, how would you ever know that you had express consent? Because if someone gave you their number today, and let's say called you on the phone and says, hi, this is my telephone number, how would you know in several weeks from now that they maybe didn't disconnect the number, failed to pay the bill, so their service was terminated, and that number was reassigned to another? So you can get it today, and tomorrow that number is reassigned to someone else. How could you ever gauge your liability? You cannot. And that was my argument to the FCC. You've got to give it a pass and an exemption for wrong number calls where the number was originally given with express consent, because you never know how, if, and when you have consent, because a number can be reassigned willy-nilly. So that's what the Breslow case is basically arguing to the 11th Circuit Court of Appeals. And it's saying, look, if the person who we intended to call, who we had consent to call with, please give us a pass for those persons who are intended recipient. And let's say only the intended recipient of the call has standing to sue. This case is basically saying, I want you to give us a ruling that is completely different and contrary to that which was rendered by the 7th Circuit Court of Appeals in the Soppick case. It's going to be very interesting to see. Breslow case is going to be heard July 15th at the Federal Circuit Court of Appeals, the 11th Circuit. I would suspect that they would issue a ruling within anywhere from 60 to 120 days thereafter, maybe longer. So it'll be interesting to see how the 11th Circuit rules on the same issue that the Soppick Court was faced on. Soppick Court is a very bad decision because they're saying, hey, if you are the subscriber to the phone, and as other courts say, if you are, quote, a wrong number called party, sorry, you are any called party as that phrase is used under the TCPA, and basically you have standing to sue and to bring a claim. Next. Okay, this has been an issue that's come up as of late, and I'm just going to go through it very, very briefly because I do want to get to a lot of the questions and get to the compliance section. Liabilities of officers and directors. Can officers and directors be sued in these suits that are being brought either on an individual or class action basis? Does a plaintiff have any right to put the officers and directors of a company in a lawsuit? Let's say they sue company X and its president. Well, the case law seems to boil down to this. If the president of the company or the person basically has some kind of control over the TCPA protocol and has some input into how TCPA and its protocol and compliance is being directed at the individual company, then maybe, yes, they can be named as an individual in the lawsuit. If not, they can't be named just by virtue of their office. Just because of the vice president or the president, they shouldn't automatically, quote, be able to be named in a lawsuit. It also doesn't mean that they automatically get a free pass just because they're an officer or director. That doesn't mean that they automatically should not be named in a suit. The cases, the majority throughout the country seems to be suggested. All is about direct input and what is the involvement in the TCPA protocol at issue. Direct participation is basically the key. In the TCPA, it's interesting. The language of the TCPA, there is no language that says if you make calls, if the calls are made by you or on behalf of anyone else, they're liable as well. It doesn't say that in the main part of the TCPA. There is a telemarketing part of the TCPA that does have this on behalf of language, but there isn't. So there isn't automatic what is called vicarious liability, meaning if you, as let's say a debt collector, make a call, it doesn't mean that just by making that call your creditor automatically has potential liability and they have this vicarious liability such that they could be liable. But that's what the TCPA and the law says. But if the FCC ruling of 2008 is followed, the FCC itself has said, as you remember, by the way, creditors, you're in the best position, and so are you, debt collectors. So creditors and debt collectors, with regard to this implied consent issue, you have the duty to prove consent. It's your burden. The Florida court in that Mays decision, those are one of the issues that's going up to the appeal because that court in the Mays case also looked at the vicarious liability issue and said, wait a minute, FCC, there's no vicarious liability prong in the main part of the TCPA under the B1A section, the cell phone section, and the landline section. There's no on behalf of language, and you're just adding a vicarious liability provision where none previously existed. You can't do that, FCC. You don't have the right. You exceeded your authority. So the district court Mays challenged that prong of the FCC ruling. That's also going to go up on appeal. So I know this is all very complex. I know it's convoluted. I don't expect you to get this in one fell swoop. I've made the TCPA PowerPoint detailed, and I've given you the cases and given you the explanation so you can go back and actually look at it. This is too much for anyone to digest, but I wanted to give you the flavor of literally what's going on. Next, in the industry. Because plaintiffs, what they love to do in these cases, in these TCPA suits, they love to name your corporate presidents into these suits because they know it puts tremendous pressure on the company then to get rid of the case and to resolve it even quicker, and puts more pressure on a company to settle a case maybe in which they wouldn't have settled normally, because now all of a sudden you have individual corporate representatives and individuals being named in TCPA class actions. That's a very dangerous, let's say, proposition or procedure, and puts individuals at potential individual risk. Let's go to the next screen. Very quickly, with the new October 16th rules for telemarketers, the new October 16th rules said this. The FCC said this is only going to apply to telemarketers. It's not going to apply to the rest of the world. And basically, with regard to prior express consent to call someone on a cell phone via predictive dialers or pre-recorded messages, now you have to have prior written express consent. No longer is oral good enough. This rule was implemented by the FCC to be in line with the FTC's TSR telemarketing sales rules. The FCC also said that as of October 16, 2013, for telemarketers, prior express consent to make pre-recorded message calls to residential numbers, you're also going to have prior express consent where you didn't need that in the past. Plus, they're saying that the EBR exemption, which gave you a pass basically for many entities for calls to landlines leaving pre-recorded messages, no longer going to be available after October 16th. And the commercial call exemption likely doesn't apply to telemarketers because the commercial call exemption for pre-recorded calls to landlines only applies where it does not contain an unsolicited advertisement. Remember, for those of you who are not telemarketing, not doing any kind of sales or upselling within any kind of informational call you're making, then the former prior express consent standard for non-solicitation calls applies. That is, oral or written consent, express consent, you're good to go then, and you have the right to call via automated dialing equipment so long as you have that oral or written express consent. Next, it's obtaining this written express consent is very draconian different. You've got to have written consent. You've got to get the signature of the person to be called in some kind of e-sign or actual literal signature, and it's got to authorize it's not just the number, but it's got to authorize the entity at issue, the telemarketer or seller, to deliver an advertisement or a message using an automated dialing equipment. That language has to be in there. That states that you authorize us to call you via our automated dialing equipment and leave artificial or pre-recorded messages. Next. That disclosure that I just told you about has to be clear and very conspicuous. And you also have to put a phrase in there that says, hey, by signing this, you are not required to, quote, procure our services before we're going to allow you to enter into such an agreement. So that has to be clearly stated as well. Next. Let's talk about compliance issues. Again, to protect yourselves to the best of your abilities is to, whenever you get numbers and whenever you get data from anyone, it is to constantly scrub those numbers. Use caller identification programs that can identify cell phone numbers. And unless you know you have express consent to call, then segregate those numbers and never let those numbers be dialed via your dialing equipment until you know you have such express consent. How do you get it? You have to actually make a manual dialed calls. Manually dialed calls do not give rise to TCPA liability. One case even says if you're using a manual phone, and even if that phone is hooked up to the company's dialing equipment, but it didn't route the call through a dialer, it just was literally a manual phone call, then maybe there's no TCPA liability for using the manual dial phone. Literal manual dial calls do not give rise to TCPA liability. Just to make sure that you are calling, you're getting consent, you're capturing the consent, and you're documenting that consent in your account notes, in your computer notes, whatever you're using, so you have a protocol to capture it. Of course, for those of you who do use recording equipment and you record every call, then you are probably capturing consent, express consent, not only in writing and you're documenting in account notes, but you've got the recording to back you up. Those of you that have written consent, well, you're in a much better position. If you can have those of you who can get your creditor clients to use broad express consent language in contracts, that is a great boon. There's language that can be used and devised that gives a very broad consent, not only to the creditor whose application it is that the consumer is executing, but that consent can be phrased very broadly to include not only the consumer, but anyone else down the chain who may get this debt, who may collect on it for any payment obligation, et cetera, et cetera. So the question is going to become, of course, with regard to the terms and conditions in these credit card applications, did the consumer get them in the first place? There's many companies I know that used to have a protocol that they would send the credit card and then weeks later send the terms and conditions. 9 times out of 10, you're going to have a consumer verifying under oath that they never got those terms and conditions. Therefore, they never got this, quote, they never bound themselves to any kind of express consent. And it's interesting, this Roberts versus PayPal case, at the very end of the case, really addresses this issue, but very briefly. And it says, look, if you have express consent that's broadly construed, it's contained in terms and conditions, but the consumer is not aware of it because they never got them, it's not going to be binding. So you've got to be very careful what is your protocol for giving the terms and conditions in relation to new credit applications, loan applications, et cetera, to the consumer. It's best to have it in the credit application itself that the consumer has to sign. Therefore, they're signing a document that contains the express consent terms. If you're sending them something separately, and even though you can prove you had a protocol to do so, if the consumer says, I never got them and I never read them, then you're going to have a disputed issue of fact, and you don't want to be in that situation. Never capture numbers on inbound calls and never load them into your dialer, okay? Manually dial the call to capture that express consent when you can. Next. Preview power dialing, we discussed this. It's a Santander case. Many courts could also construe that this is not a workaround as to the FCC's ruling. If the court says it's bound by the FCC ruling, then they're going to look at what is the capacity of the equipment. Does it have the capacity to dial without human intervention? That's what they're going to look at. Train your collectors to seek proper express consent to call numbers associated with an account. That's very important. It's not just having the custom and practice and the business practice to document. It's all about the training. Make sure that you have software that allows you to put telephone numbers in cell phone fields, a cell phone field that designates cell phone without consent, cell phone with consent. The field that says cell phone without consent, to program it so that your dialer can never call or pick up that number and call it automatically unless it's in a cell phone field that says, yes, you have it with express consent. Always be able to distinguish numbers that you've gotten from your clients versus what you get from skip tracing, because this skip tracing in one case has given rise to a potential class action. Very, very dangerous. And for those of you, we talked about this earlier, look at your dialers. Have your IT people examine your dialers. Call your dialer company and your dialer servicer and ask them if the dialer that you have from them is a dialer which contains a random or sequential number generator program, which is really from the TCPA's definition. And where I'm going there is this. If you get a court to say, hey, the FCC, we're throwing out their ruling on dialers, forget it, it doesn't make sense, and it's contrary to the TCPA, you don't want to be stuck looking at the TCPA and say, wow, it's only the TCPA dialer definition that applies. Oops, I've got a dialer that has a random and sequential number generator program. So I would not only be dinged under the FCC's pronouncement, but even under the TCPA, I could have a severe problem as well. Very important to know what your dialer does and does not have in it. Look at, this is also another issue that is very, very important. In that Meyer Ninth Circuit decision, the court said, hey, defendant, there was an admission in your securities filings that you use a predictive dialer. Since I'm going to rely on the FCC ruling as to what is a dialer, and they say a predictive dialer is a dialer under the TCPA, well, you admitted that you got one, so we got you. So that part of the case is already removed because we've got an admission. Look at your securities filings, what you say on your websites, what you say in your response to requests for proposals for new business. To the extent you can avoid ever saying anything about dialers, predictive dialers, automatic dialers, dialers that can dial thousands of numbers in a short period of time. Delete all those references. I know why you put them in there. I know why it helps you. But unfortunately, with the TCPA, it's more of a hindrance. Take out any word that deals with dialers, predictive, auto dialers, HEDS, etc. And anything that the public could get access to. Next. That's basically the end of this presentation. I know I gave you an absolute mouthful. We still have time for questions, and I want to get to all of your questions, and I will do so. And I don't see any questions that have yet popped on the screen, but I may not be seeing them. So to the extent that there are questions, Ryan, if you could feed them to me. And I'm not seeing any questions. Ryan, are you still on the line? I just want to hear it from you that there are no questions. I just may not be seeing them.
Oh, David,
sorry. I
sorry.
would be surprised that within that whole lecture, that's okay. There we go.
You hear me now? Sorry, I muted myself. I just wanted to thank you for the tremendous amount of information and research and just call to action that people, I think, have been able to come back from in the last hour and a half. And we do have questions. Let me make you a organizer so you can see some of these come up. Let's see. Actually, I'll just go through them. There's quite a few, and I was trying to hold these back.
Right. I don't have any in front of me.
Yeah, let me. I'll just kind of go through them. The first one here is about the interpretation of the automated dialing system, how the courts are defining automated dialing system. Are there a couple questions that maybe you can go back to your vendor that you're using or your IT folk if you're using an internal system to ask them in order to see what you have and how it qualifies?
That's right. It's what I said before in the compliance section. Always go back to your vendor. See what your dialer has. The first thing is, does your dialer first fall under the TCPA's definition? Does it have that random or sequential number generator program? That's number one. That doesn't mean that's an absolute, but by eliminating that program, you eliminate a huge argument that the plaintiff would have to say that your dialer falls under the TCPA. Of course, the FCC is a different issue. The FCC rulings are so broad, that is bringing almost any type of dialing equipment into the fold. The question is also, do you have a dialer that has the capacity to dial without human intervention?
Great. I think those are some good points. Now, on the one issue that came up, a couple of people had the question of, in regards to, I'm an outsourced call center. Can I rely on the consent that my client tells me they're getting for TCPA to make calls on their behalf?
The problem is that when you're getting representations from clients saying, yes, we have consent, unless they warrant that in writing, and even if they do, it doesn't mean that you're not going to have potential liability yourself under the TCPA, especially based upon the FCC rulings in the TCPA itself. The question is, do you know conclusively? And I'm just going to give an example. Let's say the entity or creditor on whose behalf you're collecting has prior express consent from everyone in writing, and it's only in credit applications, and that is the only way your creditor ever gets phone numbers. In other words, if they're transferring a number to you, they're warranting that the only way that they could get a number is from an application. They never use third-party sources to obtain any other data from the consumer. If that's true and you're collecting on their behalf, you probably have a good argument that as long as the creditor has consent, you step into their shoes by virtue of that FCC 2008 consent ruling. But be careful. Just because your creditor says, oh, yeah, we got consent, you need to vet that. You need to find out how they're getting consent. Just because they transmit data to you in phone numbers, by loading them into your dials willy-nilly, if the creditor passes on to the debt collector, you never know if that creditor has consent. You never know if the creditor got the numbers from third-party sources, how many millions of numbers they may have gotten in that regard. You need to know. You can't go about it blindly. I know many companies were saying, gosh, based on the FCC ruling, all I have to do is get the number from my creditor, load it into the dialer, I'm good to go. No, not if the FCC's pronouncement is right that the burden on proving consent rests with the creditor and the debt collector. How are you going to prove it?
Yeah, that's a lot to consider, and I think a lot of outsourcers have to rely on that just by virtue of having to, work with their clients. But let's go on to that's a question you can probably take offline for a little while. Next question is, would a predictive dial call to a residential line be subject to the prior consent requirement if it plays a recorded message if the call is answered when no agent is available? So they're playing the abandoned call message. Is then that going to be subject to consent?
I think I understand the question, and forgive me, I don't have any of the questions in front of me. I think if you're launching a call via a pre-recorded message, in other words, that's the first thing the person hears. Forget about the abandoned call message issue, which pertains to the sellers or telemarketers. They have to have a certain abandoned call message, and it's too complicated to get into all of that, what that means and how that should work. But suffice it to say that if you're launching a call with a pre-recorded message, that is a potential trigger for TCPA liability. Remember, TCPA says when you're calling a cell phone, if you make a call via an automatic telephone dialing system or a pre-recorded message is one of your triggers. If that's the first thing that the person hears, then you have potential TCPA liability unless you have express consent. And in some cases, as you know, for telemarketers and upsellers, it's express written consent.
The next question is, we talked about call forwarding, and we went through how that's handled at the courts. What about an application that does simultaneous ring, where they have it set up where it's not necessarily forwarding the call, it's simultaneously ringing a cell phone, another office line, maybe a secondary backup, a Google Voice line? Has there been any of that you've run across that you can talk about?
I don't know any cases offhand on that particular issue. I think I sort of understand the question that you're saying. If someone calls a cell phone, but it simultaneously triggers some kind of other type of notification mechanism, is there potential liability? And I think I know where you're going with this. There is a company called eVoice out there, and eVoice is a company that you can sign up for their service, and they could handle all your messages, your calls, etc., and then transmit them to you in various different ways. They can forward them to your cell phone. They can give you an email message. They can maybe give you something on a VoIP phone. I don't know all the mechanisms, the way it would work. But I believe if the company itself or the system emanates from a landline, then I would argue that there's no potential TCPA liability for a call to a cell phone. You're looking at the landline prong of the TCPA, what I call the B1B section of the TCPA, not the B1A, which is cell phones. And that's the way I would argue that type of issue, though it gets complex, and we saw that recent Lynn decision, which was saying that a call to a VoIP phone, voice over internet protocol, which in fact emanated and started from a landline number, the court put it into the B1A cell phone bag, calls or other devices for which the called party is charged for the call. That's, again, a crazy decision out there, and I think it's wrong and was interpreted wrong, but that's one court's interpretation. But basically, you've got to look for from whence the call emanates. If you, as a collection agency, are calling a landline, I would always argue that the call's a landline. It was never ported to a cell phone. If it was forwarded or transmitted by some other means, that's fine, but until that number's character is changed to where it no longer is a landline and becomes a ported number, a wireless number, it is and always remains a wireless number. Smells like it, sounds like it, looks like it, it is a wire line, meaning a landline as opposed to wireless call.
And that's a good segue into the next question, which is, does scrubbing reduce the liability? Meaning,
Sure.
Or if you're scrubbing for cell phones, you have a policy in place, you're a customer of ours, you have the records that you purged your list, did it on within 15 days or even greater, you had you were using a valid vendor that actually got you a New Star license that had all the ducks in a row. Is that helpful if you get accused of calling cell phones on the dialer, if you have to go defend a case?
It is. Unfortunately, the TCPA is construed by most courts as a strict liability statute. And in short, what that means is, sorry, you violate the law and you're dinged. Is there any out? Is there any exemption? That's the only thing that you have. Is there any free passes? And it looks like, as you know, most of the free passes, unfortunately, are on the landline side, not the cell phone side. Those exemptions that the FCC gave for calls to landlines, they are not on the cell phone side. There is no FCC exemption for a call to a cell phone. It is, you either have prior express consent or you don't, or as the FCC said, if you're a collector collecting on behalf of some kind of creditor or a collector collecting on behalf of a third party and they have consent, you get pass-through consent, and you too, collector, have express consent to call. But scrubbing is key, and if you're scrubbing your numbers, you're doing the right protocol, but you got to do something with that. It's scrubbing the numbers, weeding them out. And if you're doing that, you're doing your job and you're not calling those numbers until you determine that you have prior express consent, you may have a one-off claim, but it would be, plaintiff would have a very difficult time, if any, to be able to establish that you're calling numbers on cell phones without prior express consent because you're not doing it. If you have the protocol to scrub them all out, then how does plaintiff have a class?
And a lot of people get confused in terms of what you need to do to scrub wireless numbers, and we make it fairly simple because we have it all built into our platform, but there are multiple databases you have to tap into to ID a cell phone. You have to pull down whether it belongs to the area code and exchange, and the blocks of numbers essentially are associated with a wireless carrier. And then, like we talked about, you've got to overlay that with the ported numbers. And so it takes quite a bit to keep that updated and then provide an accurate, reliable solution. So for anybody that's on the call today, they want to do a test to verify that either what they're doing now or the data they have in their system to get an idea of what the amount of records they're going to need to get express consent, or how much data calling ability they may lose after October 16th. We've seen a lot of people.
Very good point. It's very difficult. It's the record keeping is going to be absolutely key here. Again, for those who don't have to get written express consent, having a recording and a documentation policy is great. To the extent that you're, let's say, collecting for a creditor who then has prior express consent and it's only in the written applications and you get all of that data, well, then you have it. If it's data that you can easily get from your creditor, if you should need it on a wide-scale basis, that's going to help you, although that sometimes can be cumbersome and difficult. It's getting, it's documenting and getting express written consent. For those of you who have to get express written consent, make sure that you're documenting that you have a protocol for it, that you've set up a business model for that, so that you can say, we know that we have to comply with this, we've set it up, we've got a protocol for express written consent, we only call cell phones with that, and every express consent that we have is documented and kept in this particular file, and we have easy access to it, we could easily prove it.
That is another kind of good segue into one of the things we didn't talk specifically about, but it is not exempted from the TCPA, which is business-to-business calls that are made to a wireless phone number using a dialer. And so there's been a couple of questions about, well, what if I do this, which is, we get the same question. I'm business-to-business. I have some sort of dialer. that's automated, what do I need to comply with? And usually what nets out is the fact, hey, you need to still scrub cell phones. Is that
Yes.
what you recommend as well?
Yes, I would, because there is no general business-to-business pass, and there's several cases that have said that calls to businesses on a cell phone without prior express consent, there's no exemption in the regulations. So you've got to be very careful. Of course, most of the business calls you're making are usually to a landline, but you could be making business calls to a cell phone. There may be a question there, which this whole argument gets very complicated. Who has standing in that respect to bring the case? Is it the subscriber to the cell phone? Is it going to be the, quote, regular loser? Freudian slip there. Regular user of the cell phone? Are they going to have standing? So are they any called party under the TCPA? These are all questions that could be litigated, but there's no free pass. Just your cell phones, please scrub them. The reason why we always stress the highest level of compliance is because there aren't much in the way of defenses to TCPA cases. It's just the truth. As I said, there's not a level playing field. This is what I'm literally advocating for. This is what I fight in class action litigation with judges every day. I probably have 15 TCPA class action litigation going on right now, and I'm fighting with the judges on all the time that there is no level playing field here. You've got to construe these rules in some way that's reasonable and rational, or else there is no defense to these claims based on the way some of the courts are interpreting it. And that's not the way statutes are supposed to be construed.
You know, you touched
Sorry,
on
I went on my soapbox there.
Yeah, no, and then this question kind of goes into a couple of things you touched upon, which is the industries that are trying to correct the FCC issues along with your work. I know you've done a lot with the ACA. What is kind of the current situation with that? Is there hope on the horizon, or are we destined to be, have a bunch of reps sitting in a room hand dialing? Is it going to force people to call offshore? I mean, there's a lot that
very good questions, and I'll cut to the chase with this. With respect to what can be done, there are numerous industries that are working on legislation right now to change the TCPA to bring it current. And that's being done right now. As far as I know, that there is no particular congressmen or senators who have signed on to any particular legislation, but that is being pushed. But I think where the quicker relief is going to come, if you're looking for realistic relief, it would be by the FCC, because once they issue an order, the order is implemented within X amount of days. And therefore, the quicker relief is going to become with the FCC. The FCC has so many pending petitions before it. I know that they're struggling greatly with what to do, but the pressure from even those who haven't given them petitions but are putting the pressure, the airline industry, the banking industry, the healthcare industry, they are pounding the FCC on a daily basis. The ACA has, NARCA has, the DBA, contact center compliance, they're pounding the FCC through meetings, through visits, through writings. I realize that the FCC doesn't move that fast, but with the pressure that's on them and with a slightly different regulatory climate, I am informed that the new head of the FCC, I believe that Mr. Jankowski has stepped down. He is coming in, and I hear that he may be somewhat business favorable. We're not sure the new individual, and forgive me, I forgot his name offhand, who's going to be coming in now as the new head of the FCC. And the FCC has recently said in their recent soundbite petition, look, we're trying to be friendly to businesses. We're not anti-business. We're showing that these are reasonable business rules. So I think that the FCC has to take that and go a step further. It's interesting that all of the bad FCC decisions, and I'm not getting political here, but all of the bad decisions that came out of that FCC 2008 ruling, the ones about dialers, the consent side, yes, that was good stuff, but then on the flip side, in the same ruling, they made these horrible dialer pronouncements. That's the FCC. They give it and they take it. But that was all under Bush administration. Those rules are from 2003 and 2008, all during the Bush administration, during a conservative administration, and we got terrible rulings that horribly impacted the credit and debt collection and in every other industry out there because it hurt other industries as well. banking, healthcare, anyone who uses a dialer for any purposes has been impacted by that 2008 ruling. So it's going to be through the FCC. With the Communication Innovators Petition, I believe that's the first one that they will rule on. And with all the pressure on them, plus that petition out there, we're going to see something soon. I don't know what it is. Yes, of course, I asked the question of when are you going to issue a ruling on what Communication Innovators has requested, and we did not get of course, a response. I didn't expect to, and they wouldn't tell me. But, I mean, it could be a month from now. It could be a week from now. It could be 8 months from now. All of the commentary period has well long closed, so they have everything they need in which to make the ruling. It's just, when are they going to do it? With the pressure on from every single industry across the country, I can't imagine that it's not going to be sooner than later. But you do have all the industries that literally work, for those of you who are on the phone, they are working day and night. And I mean that literally. I'm not just giving you lip service because I'm involved with so much of what is going on behind the scenes, potential legislation, et cetera, that they are working as hard as humanly possible to get things, to promote things, to get legislative changes, to get the FCC to act and to act now. Look, every industry needs relief. The time is now. Hopefully something will come in the near term, and my hope would be that the FCC would say, we're pulling our pronouncement regarding predictive dialers. We're going to yank that decision from 2008. It no longer exists. The TCPA definition is in play right now. Go at it. Because just remember, the FCC told us, and very clearly, David, don't come to me and ask me to rewrite the law. We're not allowed to do that. Yes, of course, they did that, and they won't admit it, but they did do it with regard to their dialer definition in 2008. But they say, come to us with things that we can do, not that we can't do, and that's exactly what we did. We asked them for reasonable changes. Pull your predictive dialers pronouncement. Pull your pronouncement regarding capacity to dial without human intervention because of the danger of that pronouncement and the breadth of it and the fact that it literally contradicts the TCPA. So we asked them to pull those pronouncements and give a pass for wrong number calls, give an exemption for wrong number calls. That's a reasonable request that they can do, and to allow companies to defend themselves, because the SOPA decision basically says, oh, now you can't defend yourselves in silence. It says against wrong number calls. That's crazy. I hope that answered the question.
It did. I mean, and I think that there are groups out there that are active, and you know, the FCC I think does read a lot of comments and petitions, and of course, you know, you've got, you know, local political leaders that, you know, they may not be completely aware that the business that can be lost from this. I mean, going from predictive to preview to a manual call to a demographic of people that are almost everybody I know has a cell phone, or if they have a landline, they don't answer it. It makes it very difficult to run call programs or programs where people want information. They're going to a website, you're following up with them, or you have to contact them because they defaulted on a debt. So it is a major issue that I think you know, come October 16th, and once we get farther along, you're going to see more class actions. You're going to see more people trying to sue for damages, and you know, just looking for an easy way to make money. I know that there's a lot of chatter out there on the web about this stuff, especially with the consumer advocacy groups.
Ryan, more questions?
Yeah, we got a couple more here. We got a couple more minutes. As far as the opt-in express consent requirement, is it allowed to be done via a web form? Does it have to be a checkbox? Is there kind of a standard or standard statement? What I mean, I'm sure this has come up before where, you know, somebody goes, okay, great, I need express consent, or it's now going to be express written consent. Kind of touched on, you know, the better options out there. What do you usually recommend your clients do to lock it down so that it's not questionable?
Well, express consent is, of course, supposed to be written consent. It's got to be in some kind of written agreement. Can it be with an e-signed document? Yes, it is. I mean, the questions have come up. Can you get it via email? Probably can, as long as you're getting some kind of electronic signature. Can it come by the internet? Yes. Telephone key press, that's questionable. There's, that's going to be one of the issues and the challenges of the day, and I could go into a 20-minute discussion of the opt-in and the opt-out and how you do that, and that would be a longer discussion than we have time for with regard to the limited questions we have, and I could actually discuss that in another session or at length with the requester at a different time.
And another person brought up another good question, just to kind of switch gears a little bit, which is something we didn't talk about, which is state calling rules. And the question was, okay, what if you had a state rule that would override the TCPA? For example, there's 5 states out there that we track for that we consider almost wireless do not call states because you can't even manually call a wireless number in these states. So would the state rule override? I mean, yeah, it could.
Very good. Sure, very good question. And that gets into the issue of, or the word preemption. And I'll just use the word trump. Does the TCPA trump a state law that tries to regulate the same thing? There is a decision out of the Indiana federal courts that one of the Indiana dialer laws that literally tried to regulate the same thing as the TCPA, the federal court there said, well, wait a second, this is trying to regulate something that Congress has already regulated. You can't, on a state-by-state basis, regulate it. Therefore, we're going to say that the TCPA trumps this particular Indiana rule or statute. Is that going to happen in every case? No. We'd have to look on it on a state-by-state basis to see whether the restriction by the state is something that contradicts the TCPA. To the extent that a statute or a state rule may provide or impose a greater burden, that doesn't necessarily trump or preempt a federal statute. But if the state does conflict with the federal statute and requires different requirements, that which is required on a uniform basis by the TCPA, then you could have a potential trumping of the state court law, and that state court law may be struck down. It may be, quote, preempted by the federal law. So it just depends what exactly the state statute says. And I know a couple of which I believe that I can think of offhand that I know do not conflict, but many of which do conflict with the TCPA itself.
Yeah, and I see a lot of my clients running into state issues because they're very quick to act. They don't necessarily compile complaints a lot of times like the FCC or FTC does. It's you get a couple complaints, you're going to get a letter. And, in a case like that, you want to respond quickly and deal with it, but you also want to make sure that you're staying clear and on top of states like Indiana or Arizona that Arizona's got a couple of rules about calling cell phones, just so that you're not landing in their pit because they just, they're looking for companies to go after. Got a couple more questions. I'm trying to pick ones that are really on topic. So we got a lot of questions about the type of preview dialing that's allowed, whether or not allowed, I should say, kind of out of Santander. But if there's something that's tied to a preview dialer where the agent has to click to make the call, or there's some key press, or the human intervention piece comes into play, how does that help or hurt a company, or where are you kind of at with your analysis of that whole situation? Because that case has been the one that I've heard the most about.
Yeah, we talked about this pretty well today, and hopefully in some depth, but I understand what kind of preview dialing. It's basically what I think the courts are going to do. They're going to say, you may have used preview dialing on this given campaign, and maybe a court gives you a pass for that given campaign, but they'll say, wait a second, on other campaigns you used your dialer straight out, and it's a dialer which has the, quote, capacity to dial numbers without human intervention, as the FCC says. So therefore, they're going to say, so basically you were using a dialer that falls into the purview of the TCPA in accordance with the FCC's broader pronouncement that Court X is going to follow. So preview dialing, there is no set standard of how to do the preview dialing to get around it. I think if you're going to do preview dialing, you're going to use your dialer to actually funnel the call, I think you would have a very good argument that if you disengage the automated ability to dial that the dialer may have had at one time or has, then I think you can make an argument that this dialer can't dial without human intervention. It can't do it. It can only dial in preview mode, period, end of story. There's no way to dial in any other means. It can't dial automatically, and we've reconfigured it such that that's the only way it can dial. So if that's the rule, and if that's how you've changed your dialer protocol, you may have a very good argument that your dialer doesn't fall under the FCC's pronouncements of an automated telephone dialing system.
And how the question somebody else has, well, how does a consumer know that they were called with a preview dialer? You know, with a predictive dialer, people, you know, you experience the little delay time. There's a transfer sometimes where it's pretty obvious. With a preview dialer, it's a one-to-one connection. Do the class action, I want to call them ambulance chasing attorneys, kind of just assume that you're using some sort of dialer and then just go off of that basis, or?
And I'll answer this question without getting into the entire telemarketing rules and the FCC rules, the new ones that have been implemented with respect to the timing of giving certain recorded warnings and disclosures, et cetera, and the delay in actually having a live agent answer the call once you get a greeting, because that's so complex and we don't have time for that here. That's for another discussion. But if you are, this is what the triggers of the TCPA are for what I'm seeing. What if someone is knowing, it's two things. They either have, there's such a delay on the phone line that they know that, gosh, I know that companies who use these dialers, because they're looking up it up on the internet, have these big lags and delays, and when I see one, they're probably using the dialer. But that's not necessarily the trigger for the majority of the public. The majority, the trigger is a pre-recorded message. That's an easy one. Hey, I've been getting all these pre-recorded messages, and let's say hundreds are left. If you're leaving hundreds of pre-recorded messages, someone's going to go to an attorney, and even if the consumer doesn't know, the attorney's going to sniff out, oh, wow, I think you may have a TCPA claim here. So it's the pre-recorded message that's the bigger trigger, I think, for potential TCPA. And I'm not saying that getting a live agent on the phone isn't, but less people are going to be attuned to or savvy to know that some kind of delay in a call means that you're using an automatic telephone dialing system under the TCPA. That's a stretch. Most people don't even know, let's be honest, what the TCPA is. But these pre-recorded messages, they know that there's something wrong, and they know the word robocall. That's out there in the world. That's out there in all the blogs, and people spin the word robocall with pre-recorded messages and telemarketing calls and telemarketing messages, and that's what people are attuned to. So it's just something to be very cognizant of, that it's the pre-recorded. I'm not saying don't leave pre-recorded messages, but they are certainly a trigger for potential liability.
And that liability, this was another question, is it's $500 up to $1,500 per incident, plus the FCC can come after you themselves at $16,000 per violation. And then I've also had clients who have told me that some of the cell phone carriers, especially Verizon, has actually taken action against people calling cell phone numbers on their network because they're concerned about their users being disturbed. So that's correct, right? The fines and the liability in terms of monetary damages?
The fines are when you're looking at the FCC enforcement rules and the FT, that's T as in Tom, FTC's enforcement rules, but that's on the telemarketing side. You don't see that on the debt collection side. And whether the FTC, I have not yet seen that the FTC or the FCC has gone after anyone, because most of these type of enforcement provisions are only that which the FCC or the FDCPA can come after, and trust me, they have their hands full here. So I haven't seen that yet. It's not that I'm telling the telemarketing and sellers to not be mindful of it. You do need to be mindful of some of these rules and the telemarketing sales rules and the type of damages that and the fines and penalties that the FTC and the FCC can implement. It's just a question of how aggressive are they going to go after a particular company on a one-off basis.
Yeah, and that's just, I mean, you may be in an industry like payday loans or some other, you know, homeowner relief type programs that an AG or a class action attorney is just going to look at and take action on. So, you know, there's just a lot to be wary of. And if you have more questions about more of the telemarketing side of the law, we do have a lot of resources around there. We're trying to keep this session focused on TCPA, dialers, and keep it in that context because, in a way, it, like David explained, it kind of extends beyond what the do not call list, which I think just about turns 10 years old this month, really covers. Because if you think about it, most people have a cell phone, so they're automatically going to be in the mix of in the wireless device category. Most companies use some sort of automated dialing technology, and you don't get the full exemptions with the existing business relationship that you would get normally under the FTC's rules by virtue of them doing business with you, them inquiring a website. You have to go get the express written consent, and that's the part that, you know, I've asked a few people that I know, hey, would you ever give your express consent to have, you know, be auto-dialed? I mean, that's a little more difficult to get than I think a lot of people are gonna see once the rules actually do get closer to October. So I think
Ryan, forgive me. Some people, I know we're at the tail end here, literally, and people have asked, how can they get a copy of this PowerPoint?
Yeah, so we're going to send a email follow-up in the next day or two with a link to the slides that you can download, or, you know, kind of a handout version so you can get this information, because there's a lot to try to write down and follow. And then we'll also, I'm assuming the recording looks like it went through the whole time, so we'll also get a link up for that so you can get to the slides, go back to a section and kind of replay it, or share it with, you know, a high-level version with other people in your company. So we'll get that out via, you look for that email on the next couple days with those links in there that you can pull down so that you'll be able to digest this information. And again, I thank you, David, for really just putting together a really dynamite presentation. Some of the questions were actually more comments just saying, look, this is better than any other presentation I've ever heard on this topic, and just people are very thankful for the information in general. So we got a great positive feedback on. It probably were about 450 people that logged on today to get this information. So that kind of tells you something about the temperature of this issue as being kind of red hot. So.
Well, thank you all very much for allowing me to speak to all of you. I know it's always difficult when you don't see someone live and you're not looking at them, and it's a little dry, and all of this information is dry, but thank you for sticking with us for the entire time, and good luck to all of you. And if any of you have questions, you know how to reach me through the PowerPoint and my contact information. And take care, and thank you, Ryan, and Contact Center Compliance.
Thanks, David. I appreciate it. Everybody have a great afternoon.
Be well.
Bye.